Steven Crowder went to the government and tried to get them to punish Jared for sending emails to his wife. Like, he wants the government to get in and say, no, literally, don't email my wife.
Which side are you on? Which side are you on?
All right, folks, you are listening to the Valley Labor Report. My name is Jacob Morrison. I am joined today by Matt Bruenig, labor lawyer, former NLRB attorney, and defeater of Steven Crowder. So, Matt, welcome back to the show. I appreciate it.
Yeah, thanks for having me back.
Yeah, so if you would just remind people of kind of the case that you were brought in to against Steven Crowder, or I think it's probably more accurate to say that Steven Crowder brought a case first and you were brought in to defend somebody. So if you would just kind of walk us through the timeline and some of the high points for the legal arguments that your, the people on the other side were making and that you made in response.
Yeah, so Steven Crowder's former producer signed a severance agreement when he left that included a clause that said he could not disparage Crowder. And these are pretty common. And this agreement was a long time ago. I don't remember, but many, many, many years ago that this was signed. But it lasted into perpetuity. And Crowder had a very high-profile divorce with his now ex-wife Hillary. And this producer, Jared, was friends with all these people and kind of, I guess, provided some, comforting messages to his wife during the divorce, which were produced in the lawsuit. Very basic stuff, like, I would be willing to testify to this and that and whatever. And this really upset Crowder. So he says, hey, I've got a severance agreement with you in which you agreed not to disparage me. This email disparages me, and so I'm going to sue you. And before I got in, Jared, he had lawyers, very, very capable lawyers, but not labor lawyers. And he was prepared to just fight the case as a to defend himself and say, look, I didn't disparage Crowder. I was just giving my opinion in private to his wife. No disparagement. We're good to go. And that's fine. I think he would have been okay in that strategy, but it would have cost him a lot of money to defend himself, and you don't get that money back. And so I came in and had a slightly different strategy where I brought a unfair labor practice charge to the National Labor Relations Board. And in the charge, essentially, we argue that the non-disparagement clause, the mere existence of it, violates the National Labor Relations Act because workers have a right to disparage their employers, including their former employers, as long as they, do it concertedly and, for the purposes of mutual aid and protection. And so since this clause is illegal on its face, a lawsuit attempting to enforce it is a lawsuit that seeks an illegal objective and a lawsuit that is preempted. And so it's an illegal lawsuit. It's an unfair labor practice to even bring a lawsuit attempting to enforce a clause like this. And after we filed this and I explained this, I put it on my website, I went on the Majority Report, I went on your show. They seemed to realize that they had made a mistake and that this was not going to be a fruitful path for them. So they voluntarily dropped their non-disparagement lawsuit and decided to file a defamation lawsuit instead, thinking that that would protect them. No longer are they trying to enforce an illegal contract clause, they're just suing for defamation. The problem there, of course, that defamation is a very high bar, especially with a public figure, and Texas has an anti-SLAPP statute, which makes it so that, especially when public figures and corporations file these frivolous defamation suits, if you prevail, then they have to pay your attorney's fees. And so we file a motion to dismiss under this anti-SLAPP statute. We win. The judge orders Crowder to pay Jared $58,000. Crowder does sort of like an immediate appeal just to kind of preserve his appeal rights. And then we end up negotiating an agreement to settle all of it, to settle whatever claims he still had and to settle the claims that we had at the NLRB. And as part of that agreement, he paid my client money. We can't say how much, unfortunately. But he also agreed to rescind these non-disparagement and confidentiality clauses, not just from Jared's agreement, but from the agreements of all of his current and former employees.
there are ways that you could construct an NDA that would be legal under the NLRA, as long as they do not also prohibit the kind of workers' rights to basically disparage their employers for during the course of protected activity. And so it's possible that Crowder could have created an NDA that would have prohibited the conversation that Jared was having with Crowder's wife, but he didn't. That wasn't the NDA that was there. It was an illegal NDA, one that violated the National Labor Relations Act. And so even though it's possible you could have constructed an NDA that would have prohibited this, because they didn't, they can't. Is that right?
It is possible to craft a non-disparagement confidentiality clause that is not on its face illegal. It just has to be, it can't be overbroad. So if it's written in a way that a reasonable worker would read it and think that it encompasses protected activity, then it's going to be illegal on its face. So there's essentially like two paths that you can go in a kind of, in this strategy, if you will, right? The one path is just to say this clause is illegal on its face. And so any lawsuit attempting to enforce it seeks an illegal objective. It is itself an illegal lawsuit. The second path is, regardless of what it says, it may even be lawful on its face. If you're trying to enforce it against protected activity, then that is illegal for a separate reason. Any clause, no matter how it's written, if you attempt to enforce it against protected activity, that's illegal. In this case, we only had the first strategy, because what he was doing, talking to his ex-wife, that was not protected activity. But the effort to retaliate against it involved the effort to enforce an illegal clause. So yes, if they had written it a little bit better, they could have avoided this whole problem, but they didn't.
Right. Right. And so what were, when you announced this, there were obviously, as you could imagine, some people that were unhappy with you, saying that, Jared went to an Act Blue communist to fight against his former employer. And, there were just Steven Crowder fans, some of them were unhappy. What were some of the What was some of the cream of the crop legal arguments that you saw on Twitter or anywhere else that you may have seen these arguments against your winning argument in the courts?
Yeah, I mean, I think we went over it the first time you were. It's funny, after you win, all of these people who came out to say that I don't know what I'm doing, and I remember one of them was, there's no such thing as an illegal lawsuit. Like, okay, well, there's so many cases on this. Of course there is. There was that weird kind of like celebrity right-wing attorney that, I don't know, he was associated with Rittenhouse. He does kind of that stuff, I guess. And he said I don't even remember what he said, but then he started citing weird stuff in the U.S. code. Like, he didn't know what he was talking about. There was one actually very knowledgeable management side lawyer on there who said, I don't know, I think, come 2025 or 2026, your client might, be in for a rude awakening. But, we got it handled before all that. So he was not wrong about the potential risk there, but, got it dealt with before that possibility. So now there were a lot of people the first go around who were very skeptical of all this. And I mean, it's easy to be like, well, this is this internet poster guy, Matt Bruenig. He just he's full of himself. But I am a labor lawyer. I worked at the NLRB. I do actually know what I'm doing in this area. So.
Hey, 5 seconds. Just wanted to say that this is only possible because of our donors. If you want to see more of this, then consider donating yourself at tvlr.fm/donate. I'm looking at one now where you kind of go over you kind of run some libertarian types through the basics of what it means to enforce a contract. Would you go through that for our audience and explain, basically that, these contracts are not self-enforcing. It has to be the
Right.
state to do it. And so what does it mean actually to say that, we don't like the state in cases like this?
Yeah, it's one of my great hobby horses that I used to be very, very interested in when I did philosophy. Is there's this kind of incoherence to what you might think of as libertarianism or laissez-faire philosophies, where they like to think we are our view is that we want to keep the government out. I just want private individuals to make agreements with private individuals and it all be private. I just want the government out of the way. And, there's an appeal to that. I'm not saying it's totally unappealing. I wouldn't say I've had, perfectly good interactions with government either. So I get where they come from there. The problem is that all of these so-called private arrangements that you enter into, the state is always lurking in the background because they have to be the one that enforces everything, whether it's your agreements, whether it's property disputes or sales. Like the state is there setting the framework for the whole system. And this is a great illustration of this, because one of the reactions, the one that I think you're referencing, is that this is terrible. They entered into an agreement, and then now the government is saying that agreement's illegal, and they're not, I want the government out. The government shouldn't be involved in this in the first place, right? That's kind of the idea. This is against our libertarian laissez-faire principles. But what actually happened here is a great illustration of how that doesn't make sense, because what happened was, it was Steven Crowder who went to the government, who went to a court and tried to get them to punish Jared for sending emails to his wife. Like, he wants the government to get in and say, no, literally don't email my wife. And like, so he went to the government, and then we didn't go to the government. He could have managed this any number of ways, including, and I suggested this to their lawyers over and over again, why doesn't he just blast Jared on Twitter? Crowder's so huge. If he wants to, he could just, he could use his microphone or whatever, his megaphone, just blast this guy. He didn't. He wanted the state to come in and do his bidding for him. And if that's the case, like at that point, yeah, the state surely gets to say, all right, you want us to get involved in this kind of stuff? We have rules about what we're going to get involved in. And one thing we're not going to get involved in is an employer trying to prevent its former employees from talking about them.
Right. I think that's pretty succinct, very clearly. If you're going to have the state trying to enforce contracts, the state should get to say, like, what kind of contracts it wants to enforce.
And the law was out there. It's announced. Right. You can read it. I mean, it's not easy, but you could have hired, if you'd hired me to write the agreement, you probably would have had a better go of it. So
Right. Well, and so so you were able to win. You're not able to disclose the settlement amount, but you did. Part of the settlement was, I guess you didn't technically win. You settled, but I think that kind of counts as a win, because obviously what Crowder would have wanted is not to settle and not to pay Jared Monroe a bunch of money.
Right. He sued us wanting money, and he ended up paying us money. So
right. So I think even though it's not like the court didn't say, you won, I think pretty clearly that counts as a win.
Well, the district court did say we won, right? We won that one. It's just then it was appealed. But yeah, you're right. I mean, the thing is that, guess what? Every court case ends in a settlement, pretty much. I mean, unless someone just decides to stop appealing. Like a good example of this was the Johnny Depp one. That was really, everyone say Depp won. That actually ended in a settlement agreement too, because it was appealed, and then they ended up, it always ends in a settlement. So
right. Well, and so, but the thing that one of the things that you were able to win in the settlement was the ability to do this, right? You won the ability to talk about everything that has been public so far. How were you able to get them to agree to that?
Yeah, I mean, it's very simple, actually. So if you want to withdraw charges at the NLRB as part of a non-board settlement agreement, which this is, they have rules that govern what that agreement can say. And one of those rules is that the agreement cannot have any confidentiality rules except for the financial terms of the agreement. So they actually did come forward first with the initial drafts, and they wanted confidentiality over the whole thing. I then explained to them, oh no, if you want us to withdraw the board charges, the board's not going to let us do that unless you only confine it to the dollar term. So that's another way in which the board is coming in and achieving something that normally you don't achieve, because I'm sure you've probably read many news reports about lawsuits, and everything's always confidential. That's just like a default term in these agreements. But the board's position is that we're not going to allow that, except for the dollar amount. And the board is the one that decides whether your charges can be withdrawn. You can request it. You can send in a form saying, I want you to withdraw it. But once you've filed it, it's up to them. It's their case. They can decide whether to withdraw it or not.
Interesting. And so all of this that you're kind of laying out really illustrates the value of having an actual labor lawyer when you're discussing labor law and when you're trying to make moves within labor law. And I can't remember where it was that you said this, but I remember on a podcast or somewhere you said that when you got fired from the NLRB or let go or you resigned or whatever it was, there was some controversy around that. And I don't know, maybe we can get you on to talk about that sometime because I think it's a pretty funny story. But you said that you immediately got management side headhunters calling you, offering you double your salary to come do labor law for the bad guys. And so, it's just worth saying that like the knowledge that you have is very valuable, and every single NLRB attorney or union side lawyer has basically that kind of opportunity that they don't take. And so it's, just worth putting some laurels on you, I guess.
Yeah, no, I mean, you compare the management side pay to the union side pay and I mean, I know union side lawyers who are making 100K, which, I mean, look, that's good money, right? And normal workers, that's good money. You go over to the management side, the people they're going to get up against day to day, they're making triple that. And, they're not better lawyers. So there's a level of just choosing to not, take the money.
Yeah. Yeah, and it's also, I mean, a lot of union members make $100,000. I mean, I was very nearly six figures in my last job, and I know that there were staff for the union that I was a part of that didn't make as much money as I did. So I mean, union members, we do all right for ourselves too. So it's not unreasonable that our lawyers are paid as much as we are. So. I don't know if you had anything else that you wanted to add to that, but I did want to give you an opportunity to talk about your new project. You're always making new projects. This one is NLRB research, and that's really exciting for me because it seems like it'll be a really cool tool that stewards and non-lawyers can use to make use of the law. So talk to us about NLRB research, why you did it, and some of what it does.
Yeah, I actually started this before NLRB Edge, NLRBEdge.com, which is my sort of like daily update on NLRB stuff. The NLRB Edge grew out of this, but about a year ago, I don't know what, I just kind of hit me that, I bet I could write some code that would download all the documents from the NLRB website, get them all neatly organized, make them all text searchable, like make a really good tool. I used to be a programmer. I could probably do this, and the NLRB website right now is so unusable for research purposes. And so I just kind of did it, and I spent like a month or so just really pounding away, relearning a lot of programming, and it worked. And so I was able to produce this database that now has, I think, like 91,000 documents in it. And once a day, it just puts any new documents that are put on the NLRB website of a certain kind, that are legally relevant. It puts it in the database, and so it's always up to date. And it's text searchable, nice, pretty intuitive search box, and it allows you to do legal research. And I use it exclusively for my legal research. Everything I did in the Crowder case, I used NLRBresearch.com. NLRB Edge came out of that because I realized once I had it created that I also now have a list every day of everything that the NLRB puts out. And so I can use that list, get the summaries, and put it on there. And that would be useful for people who want to keep tabs on the agency. We've got 11,000 subscribers at NLRB Edge, mostly free subscribers, but some pay. So it's been a really useful tool. One of the cool things about it, all the documents have AI summaries. So, you can do a search and then you can click the AI summary and you can, just read that instead of having to read the legal text, which, sometimes can be pretty long and maybe intimidating. But yeah, I mean, any union steward who is confronted with a problem that they don't know the answer to, if they spend a little bit of time, putting words or phrases into the search box, they might find a case with the answer. And I've had a lot of feedback from stewards saying that it's been really useful for that kind of thing.
That's really exciting. So hope folks will take advantage of that. Do you have in your on your docket to do a similar thing for the FLRA?
A lot of people, you would be surprised how many emails, and not FLRA, RLA, all the state boards. Everyone wants me to do all this stuff, and I'm not against it. The novelty is that the NLRB website was so, I was going to say exploitable, but it makes it sound like I've done a bad thing. It was so susceptible to this kind of web crawling that I could write like a little Google-like web crawler just focused on the NLRB website, and it had like all the little metadata. Like it's set up reasonably well. It's just not searchable or functional on the NLRB website, and you have to go to like 13 different pages to go through the different kinds of documents. Some of them aren't searchable, et cetera, et cetera. So their website was really set up very, very well for that. But some of them like I could do it for all the Supreme Court decisions, for example, or all of the even circuit court decisions. Like I've looked at other applications of it, but yeah, I don't know if the FLRA, I think I looked at that and I decided the website was not really susceptible to it, but maybe I'll take another stab at it.
That's frustrating because as a federal employee, I'm a member of AFGE, so when I was doing grievances, it was always very difficult to kind of find like, oh, what's the precedence, or like where have cases like this been decided before, and it's just not, I don't know. It makes sense that there's not as many resources out there for federal employees in federal labor law because there's not as many people working under federal labor law as there is the NLRA, right? But it did seem like there was a serious absence of resources for navigating federal labor law for federal employee union stewards.
Yeah, no, it's tough. I mean, when I was at the NLRB, we had a union, you could imagine, and we were governed by the FLRA. And we had to hire outside lawyers to help us with our issues, though it's a
union of lawyers had to hire some different lawyers.
A union of labor lawyers who work in the labor enforcing agency was like, yeah, FLRA, I don't know. So.
Wow. Because it's a different law. Because like what the labor law that you enforced as the NLRB attorneys was not the same labor law that you worked under, and so you had to get somebody who specialized in a different set of laws. That's interesting. Yeah, I don't know. It might be worth maybe you could reach out to AFGE and see if they'd pay you to do it.
Yeah, it would be in a way like a more direct. Like there's a smaller group of possible client. You really could just hit one or two unions and be like, come on. Whereas this one is a little bit harder to be like called up the Teamsters and be like, I got this website.
Yeah. AFGE is definitely it really is. There's like one or two there. AFGE, IFPTE, and NIFI is the only ones with any real kind of presence in the federal sector other than, I guess, NLRBU. Which we've had NLRBU Local 10 president on the show before to talk about.
Oh, yeah.
NLRB. Yeah, so big fans of the NLRB union. All right. Well, Matt Bruenig, really appreciate you taking the time. Appreciate all of your work, everything that you do for folks, the new project or the, I guess, old project, NLRB Research, and looking forward to you following through on your commitment to create a similar tool for federal labor law.
I'll check it out. All right. Thank you for having me.
All right. Thanks, man. Bye. You just saw a clip from the Valley Labor Report. We are live every Saturday morning from 9:30 a.m. till 12:30 p.m. And we pride ourselves on keeping all of our content free to everybody so that we can talk to as many working folks as possible. If you support the work that we're doing, you think that it's important, you think that it's good, then consider making a monthly contribution to the project, and you can do that on our website, tvlr.fm.